discussion. As we know, under this administration, tens and thousands of Black women and other marginalized groups of people have lost their jobs, have been put out of work. And this is even more so compounded for folks who do have a criminal background or arrest work record. We also know that this is compounded with the number of Black women and marginalized gender folks who are oftentimes incarcerated and criminalized for defending themselves in instances of intracommunal violence and domestic violence, and how financial exploitation and financial abuse is one of those ways that people are impacted. And so strengthening our anti-discrimination laws and the resources to support people through that is about having the dignity to work, having the ability to self-determine your work, and to contribute to one's community and society, especially for folks who, again, who have been exploited prior to entering into the prison industrial system and continue to be exploited and harmed in these systems, and then come out and continue to face punishments. And so we really have to shift the culture, shift the resources, shift the structures that continue to penalize and harm people. And so we hope that this presentation will provide somewhat of a framework as far as examining the changes to federal employment anti-discrimination policies and the impact on people with arrest and conviction records, and then discussing the protections in California state law and local fair chance employment ordinances, and then also discussing best practices for advocacy with housing providers and employment providers, and organizing strategies to shift local policies. And yeah, we look forward to hearing you all's questions and following up with other types of advocacy that LSPC is involved in as it relates to fair chance employment in the California state legislature. With that, I will pass it to Eric.
Thank you very much, Nanaya. For those joining this webinar for the first time in this series, you can check out part 1 and part 2 on LAAC's archive. Part 1 was in early February and part 2 in March. But if you haven't seen those, don't worry. You won't hopefully be too lost in this one. We're endeavoring to make it somewhat self-standing. In part 2 was about housing. This session, part 3, is just about employment. And part 1 spoke about both housing and employment. And just as a reminder, so in part 1, I discussed the case Griggs versus Duke Power, which was a landmark case decided by the Supreme Court in the early 70s that solidified disparate impact interpretations of the Civil Rights Act. We also discussed the Green factors coming out of the Green versus Missouri Railroad case that dealt with criminal history as a and its disparate impact on race. And in that decision, the court articulated, that came out of the Eighth Circuit, but then it was adopted pretty much nationwide, articulated factors that employers needed to consider in order to not be liable under Title VII when using criminal history, including arrest or conviction history in employment decisions. And we touched on the 2012 Equal Employment Opportunity Commission guidance on criminal history, which we're going to talk a little bit more about today, which is possibly on the chopping block from the current Trump administration, as you may have heard. As a recap, from last time, I spoke about the case that arose out of the city of New Haven, Ritchie versus DeStefano, in which there was a test that the city believed would subject it to disparate impact liability, where a test for applicants for the position of firefighters with the municipality had a racially discriminatory effect. And so they tossed out that test. Some of the applicants sued and regarded that as potentially discriminatory treatment. And the court, through the pen of Kennedy, basically found that the city in that case didn't have sufficient evidence to support its rationale that it would be liable for disparate impact liability, and gave this sort of vague standard that they would need to have a strong basis in evidence that it would have been subject to such liability. Now, I mentioned last time that Justice Scalia wrote a concurrence where he said that there is a question that the court will need to confront as to whether the disparate impact provisions of Title VII are consistent with the Constitution's Equal Protection Clause. And I concluded last time with in the part one with Scalia's statement, quote unquote, that the war between disparate impact and equal protection will be waged sooner or later. And it behooves us to begin thinking about how and on what terms to make peace between them. Now, there's both that there's a tension in legal doctrine is definitely true, but there's also some misleading aspects of that quote that I want to highlight. So this presupposes, of course, that Scalia's understanding of equal protection is the correct one, which is not at all obvious. And so in his view of what equal protection is, it is aligned with discriminatory treatment, and in particular with intentional discrimination as a form of animus. Now, so of course the 14th Amendment post-Civil War environment uses the phrase that states cannot deny to any person within its jurisdiction the equal protection of the laws. And Section 5 gives Congress the power to enforce that through appropriate legislation. The Section 1 was principally drafted by Congressman Bingham. He was influenced by Senator Sumner, who had argued a couple decades prior that the Declaration of Independence implied that all citizens, by which he meant everyone born in the U.S., regardless of race or national origin, were entitled to equality before the law, using a kind of classical trope. And in between the passage by Congress and the ratification by the states, Sumner went on a series of lectures where he gave a famous speech in different iterations, arguing for equal rights of all, that the nation was bound to protect. And he was doing this in the context of a critique of a federalist model that offered strong states' rights versus what he considered a national model, which had a stronger federal government. Now, the term protection also has a range of legal meanings dating, back to before the Revolutionary War. That certainly would have been very familiar in usage by the time of the Civil War. And you can see evidence of various senses of protection used in Blackstone's commentaries. So one of them, and I think is the most relevant, is the idea of protecting from oppression. Um, he also talks about protecting uh, civil liberties and civil rights and protection against personal injury. And Blackstone wrote, quote, "This is what we mean properly when we speak of the protection of the law, what he called the remedial part of law beyond its declaratory and directory parts." So the corrective justice whereby the righting of wrongs or the providing of a remedy for a wrong done was protection in Blackstone's usage. And then he talks about strict construction in criminal law as protecting public liberty. But then there's also other uses of protection, such as protecting the protection of institutions like law schools or churches. And then lastly, a physical sense of protection, where he talks about how the natural environment provided protection against invasion. Now, in all of these senses, protection, I argue, involves an affirmative provision of a service or creation of a condition for the enjoyment of liberty or the enjoyment of a right. And if you combine that with Sumner's emphasis on equality, you can infer that equal protection does not merely carry the connotation of the absence of an illicit intention to discriminate against a group, but rather is a sort of positive duty to create a condition for the enjoyment of rights and liberty. I will pass the mic to Beth.
Okay, I'll take the mic. Uh, Thanks so much, Eric. I learn something new listening to Eric every time he talks about case law. Um, but I'm going to jump in here to something that Eric mentioned in part one of in webinar part one of this series. Um, the EEOC guidance, which was released in 2012 and basically summarizes the law and its and disparate impact and disparate treatment actually and its application to workers with records. And it basically summarizes, how employer consideration of a worker's record can violate Title VII. So you should go back and watch part one for a little more about the basics of what it includes. But I want to zoom in on it to stress really two things. One, it really represented a significant accomplishment when it was released in 2012 or when it was issued because it drew attention to the issue of workers with records and their civil rights in employment, and because it provided additional clarity to workers, employers, and EEOC staff who are applying the law. But it's important to note that, it was purely informational and it did not actually change the law in any way or establish new rights or responsibilities. There were some employer and HR commentators at the time who were actually surprised that it didn't go further. And I think it's important to because of the moment we're in and the pushback we're getting to a lot of the things that are summarized in that guidance, I think it's important to, let's go back and understand why it wasn't totally revolutionary and, how its contents were pretty much generally accepted across the aisle at one point. So by 2012, when the guidance was issued, the EEOC had investigated and decided Title VII charges from workers challenging an employer's discriminatory use of conviction or arrest history for more than 40 years. So they'd been receiving and investigating these complaints for over 40 years. The guidance was actually not the first policy statement by the EEOC on this topic. It actually consolidated and expounded upon three previous EEOC policy statements that were issued in 1987 and 1990. Those three addressed slightly different aspects of the issue, but all made clear that employers violate Title VII with record-based exclusions that aren't supported by business necessity. The 1990 policy statement, I think, is notable because it was issued under then EEOC Chair Clarence Thomas, whose name should ring a bell. And that policy statement underscored how well, the fact that he was chair at that time really underscores how these interpretations were generally accepted across the aisle at that time. So why was the guidance updated in 2012? Why not just leave it with those three policy statements? Well, first, my understanding is that the EEOC's work toward this update began during the Bush administration, so well before 2012. And then in 2007, a Third Circuit decision, LV SEPTA, or Southeastern Pennsylvania Transportation Authority, that Circuit opinion noted that the EEOC policy statements could benefit from more detail and going a bit deeper. The EEOC then held public meetings, let's see, in 2008 and again in 2011. It was a several-year process to pull it together, and then they reviewed those public comments. And then finally, in April 2012, the EEOC approved the enforcement guidance in a 4-to-1 vote, and that vote represented bipartisan support among the commissioners. And I think those are all important things to know as you're considering the import and our current moment. Now I'll go back to Eric. I think we might have a poll, and then I think Eric's going to provide deeper analysis of case law, California law, and maybe even of the guidance.
So we have our first poll, which is, have you advised, assisted in the advising, or helped to navigate bureaucratic systems relating to criminal records in employment? And we'll let that run for a few more seconds. Okay, gonna end that one. So we had, so on that one, we have 67% yes, 26 no, 7% unsure, and no one declined to answer that question. Okay, second poll. I believe the use of criminal records in some circumstances function in employment in a disparate manner in terms of A, race, color, B, sex, C, national origin, D, religion, E, some of the above, F, all, G, none. And I can't see the result because I just closed that window and I'm not sure how to get it back. But if
They're
anyone
still coming in, so about 60.
Okay.
Okay, I think most people have participated. We have 19%. Well, I don't know on LAAC's end if y'all want to share the poll, but on my end, it's just 19% race, color, 0% for sex, 0% for national origin, 0% for religion, and then 37% for some of the above, 41% for all of the above. And I see one person put none of the above. I'm not sure about that. Yeah, so I think overwhelmingly 41% of folks said all of the above, some of the above, or a combination of race and color.
Thank you. So, okay, so just a reminder of the basic, or one of the basic statutes at issue, U.S. Code Title 42, unlawful employment practices. It's a much longer statute. Obviously, I'm just giving the first piece of it. It shall be an unlawful employment practice for an employer, one, to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals' race, color, religion, sex, or national origin, or two, to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. Now, of course, I would not be the first and certainly not the last to point out that, the phrasing of this very statute is, um, uh, uh, you know, at least has a signal of sex discrimination built into its language. Now, the term discriminate has, at least since, before 1934, had a sense of discriminating against a class as a form of social injustice. But long prior to that, there was a positive sense of discrimination where to discriminate just meant to distinguish something or to exercise discernment. And this is, I think, important to keep in mind when the focus on disparate treatment turns into a kind of like psychological moralizing conception, which is not present in, or should not be present, I think, in the concept of disparate impact, which is not to say that discriminatory treatment is not a significant problem today as well. Now, as Beth mentioned, the EEOC's 2012 guidance was one step on a long road of building up legal doctrine around the interpretation of Title VII. It found, or the EEOC advised that an arrest record in and of itself isn't job related or consistent with business necessity, but then it sort of immediately made a huge caveat to that. Sometimes the underlying conduct will make an individual, quote unquote, unfit for a particular job. Convictions, the EEOC's guidance is a lot more lenient for employers. Basically, the EEOC in 2012 said that an exclusion usually will meet the standard if they either satisfy the green factors mentioned earlier and discussed in Part 1, or if they comply with the uniform guidelines that can be found in the Code of the Federal Register regarding the use of data or analysis. So these are kind of like safe harbors, as it were, that the EEOC was offering up to employers. And the guidance notes that under Title VII, plaintiff can still prevail, notwithstanding the employer's job relatedness or business necessity justification, if she can show a less discriminatory alternative to the employer's procedure, which alternative was rejected. Now, there's a curious footnote in the guidance, which calls attention to the interpretive memorandum read by Senator Danforth in 1991 when the Civil Rights Act was amended and expanded. And when you closely read this footnote, you note that they call attention to the fact that Senator Danforth in the statement presented in the congressional record refers to business necessity and job relatedness, but then the version of the interpretation that made it into the actual Civil Rights Act of 1991 didn't refer to job relatedness, but only referred to business necessity. Now, there's a bit of a paradox of legislative intent in this instruction, I think, which raises a question which I'll just pose and not try to resolve, which is, can the legislature control the judiciary's interpretation of a statute by instructing it how and what to read? Article 1, Section 8, of course, gives Congress the power to constitute the lower courts, and Article 3, Section 1 says that Congress ordains and establishes the inferior courts, and Article 3, Section 2 also gives Congress the ability to regulate Supreme Court's appellate jurisdiction. Nevertheless, there's a longstanding tradition of sort of inherent powers of the judicial role and separation of powers, recorded most poignantly perhaps in Federalist 78 of Hamilton, which gives the judiciary the role of determining the meaning of law. And so the question is also, to what extent are expressions of the legislature's intent effective in practice? And does it matter in this particular instance whether the instruction is in the act itself versus in a legislative record, and not in the code, and also the fact that the wording differs? So what's in the act of the Civil Rights Act of 1991, as I suggested earlier, Congress expressly declared that it was repudiating certain opinions expressed by the Supreme Court in Ward's Cove, which I'll get to in a moment, as relates to business necessity and also alternative business practice. Danforth's memo talks about business necessity and job relatedness, even though job relatedness doesn't really come up in Ward's Cove, but it does form an important part of the case law prior to Ward's Cove, and that was sort of Danforth's and the other members of Congress and the Senate, in particular, where this compromise sort of originated, were keen to establish that the Griggs line of cases were what Congress approved of, not the attempt to roll that back by the then Supreme Court in the early 90s. Now, Ward's Cove, which is referred to in by the legislature, is a Supreme Court case from 1989. It held that the statistical method in that case employed to make a prima facie showing of disparate impact was inadequate. So it didn't directly have a holding that defined business necessity. And so, in a certain sense, the suggestions along the lines of what form of justification businesses could have could arguably be thought of as pure dicta in Ward's Cove. But what Congress wanted to do was sort of head off a trend that it saw, creating a disturbing rollback in the courts with respect to the protection of civil rights. So I'm going to fast forward to the almost present and briefly talk about a case out of the Second Circuit, but I think it's one that those of us in the Ninth Circuit should especially be interested in because it has to do with the tech industry. In Mandala versus NTT Data, there was a firm's blanket practice of disqualifying persons with felony convictions. There was a plaintiff's claim that this disproportionately harmed Black applicants because arrest and incarceration rates are higher than others. To prove that, or rather, just in the complaint's allegation phase, they alleged, but sort of gave corroborating citations for studies by the Department of Justice, by the Census, and by the Equal Employment Opportunity Commission that showed disproportionate effects of the criminal legal system on the Black population in the United States. Now, one might think that that should be enough at complaint stage to show a disparate impact, but the Western District of New York disagreed and said that the general stats of nationwide effects were insufficient. That was appealed. The decision was upheld. En banc was denied, and then the plaintiffs tried to have the district court's decision vacated and refile their complaint, even though they had been denied with prejudice effectively. And that was also denied, and then they appealed. Now, so in 2003, the circuit court said that no precedents had decided that that granular statistical comparators were necessary at the pleading stage, as opposed to later, after discovery, enabled them to proceed toward trial with a larger body of evidence. So they also found that the lower court erred in its technical ruling that the motion for vacatur was time barred under the rule of civil procedure 60. Then the Second Circuit said that given the plaintiff's lack of access to more granular data at the pleading stage, they might instead be able to state a claim for disparate impact by providing additional allegations to explain why their chosen national statistics are in fact likely to be representative of the firm's qualified applicant pool, or by identifying other publicly available information that could support the discrimination claim under Title VII. So that got remanded. A different judge in the district took it at the next phase and ruled in favor of the plaintiffs, allowing them to refile essentially, and also found that it was too soon to strike their allegation that they represented a class. So that's an ongoing case to watch, see how that develops out in the Second Circuit. Switching gears to another sort of topic of assault that you might say has been perpetrated by the executive branch in our time is the question of the rights of the undocumented and more generally persons without citizenship. Now, this is an interesting case from 1973, Espinoza versus Farah. The majority, which included Justice Marshall, surprisingly, found that it was consistent with the Civil Rights Act of 1964 for an employer to discriminate against non-citizens as non-citizens in employment. And they used the language of the time, quote unquote, aliens. And Marshall wrote that nothing in the act makes it illegal to discriminate on the basis of citizenship or alienage, and that they agreed that the specific facts of that case did not indicate that the respondent had engaged in unlawful discrimination because of national origin. Now, Douglas had a very interesting dissent, interesting for our purposes, because it relied on Griggs versus Duke Power Company. And Douglas would have ruled in favor of Espinoza, and what Douglas wrote, I quote as follows: "There we found that the employer could not use, speaking of Griggs, could not use test or diploma requirements which on their face were racially neutral, but which in fact had a de facto discriminatory result, and the employer was unable to justify them as related to job performance. Respondent here explicitly conceded that the citizenship requirement is imposed without regard to the alien's qualifications for the job." End of quote. Well, actually, he goes on to point out the ethnic makeup of the petitioners, and Douglas, again in dissent, says that Griggs, as he understands it, extends its protective principles to all. Now, also sort of ironically at the time, the EEOC was a amicus supporting, or maybe not so ironically, but was an amicus supporting the petitioners, and Douglas observed that their interpretation should be um, entitled to great weight, but again, taking even that with a grain of salt, that the commission may have weight as a sort of agency interpretation, but they're not for that reason binding on the courts.
Have 1 minute left.
Just briefly, I want to say a couple things about California law. So, California Government Code 12940 is the state's basic anti-discrimination employment law. Has many more categories than are contained in the Civil Rights Act's Title VII, and it has this exception for bona fide occupational qualification. The Civil Rights Department, charged with implementing that act in Title II of the California Regulations 11017.1, defines both disparate treatment and what it calls adverse impact, which is basically its version of disparate impact or substantial disparity. And that regulation is contained in the material, so I encourage folks to take a close look at that after this program. And if we have time in the Q&A, we can talk a little bit about how the CRD's interpretation of its mandate furthers protection against discrimination in California. With that, I'll kick it over to Beth.
Thanks, Eric. Yeah, I'm gonna kind of shift us a little bit and bring us kind of, I guess, to the present and what Nanaya alluded to at the beginning of like the current moment and the federal situation, or what's happening at the federal level. So even though the disparate impact framework has been applied by courts for decades, even though disparate impact was adopted into Title VII in the 90s, it's facing renewed attacks. So Eric covered again on part one of the webinar series, the April 2025 executive order attacking disparate impact. So if you want to read more about the details there, go back to that. But I'd like to circle back to summarize what's been happening at the federal level over the past year, almost exactly, since that executive order was issued. So I guess as a quick refresher, the April 2025 executive order included several provisions, and I'll lift up two. In Section 4, it directed agencies to deprioritize enforcement related to disparate impact. And in Section 6, it directed the EEOC to reconsider current cases. Now, it's important to remember the EEOC is supposed to be an independent agency, not controlled by the president. Nevertheless, you can go to the next slide, please. Next slide, please. Thank you. Nevertheless, here are some of the actions taken by this independent agency in the months following last year's executive order. So in June, Chair Lucas moved to dismiss the EEOC's only active lawsuit involving disparate impact theory. Relevant to this topic we're discussing today, the case was against Sheetz, which is a East Coast convenience store, kind of mid-Atlantic. It was a case filed by the EEOC just in 2024, so 1 year prior, for denying jobs to applicants with records in violation of Title VII. So just as an asterisk there, just so you know what happened with that case, immediately private litigants moved to intervene in that case. And they're still waiting for a ruling on that motion to intervene. So that case is still going, but the EEOC doesn't want to be a part of it anymore. It doesn't want to enforce it, is kicking it to the private bar. Then in September, the EEOC instructed staff via an internal memo to discharge all disparate impact complaints. The result of that was a lot of confusion and lots of right to sue letters. And following that, Public Citizen actually filed a lawsuit in October on behalf of an Amazon delivery driver, and they asserted that the EEOC is required by law to investigate all charges filed with it, and that the Trump administration can't order EEOC staff to stop investigating disparate impact claims. Unfortunately, that complaint was dismissed by the district court in November for lack of subject matter jurisdiction. Um, so yeah, that's where it currently stands. Um, and if you can go to the next slide, I just want to take a step back and, you know, let's look at how did the Trump administration so quickly cause the EEOC to make such reversals on, its longstanding policies? And the short answer is lots of unprecedented action. So I have a brief timeline up on the screen showing some of them, but just things to be aware of. So back in January 2025, the president fired Chair Burrows and Vice Chair Samuels, even though their terms were not set to expire until 2028 and then 2026, respectively, um, which, you know, is certainly unprecedented. Um, then the EEOC took the actions that I described on the last slide. They took those actions without a three-member quorum. Um, in Oc- so just to explain that the commission is supposed to have three commissioners in order to make certain decisions, including those related to guidance. So the EEOC regained its quorum in October. Um, I think one thing that's notable about this, I mean, these aren't like huge things, but it's just, I think, indicative of how much, how much precedent is being ignored. So Commissioner Panuccio didn't even have much of a confirmation hearing. Instead, there was a party line vote on a block of over 100 executive nominees, and then was sworn in during a government shutdown. I just think those are interesting little details. So since regaining quorum in October, the commission has just this January voted to rescind commission voting procedures. And in doing so, it eliminated significant process requirements, including guaranteed time to consider important policy decisions between the announcement of the topic to be voted on and the vote. And it also rescinded, importantly, the right for commissioners to require a public meeting before a commission policy vote. So those are things that changed in January. I'll also note, relevant to what we're talking about, that although the 2012 criminal records guidance still stands, the EEOC has already rescinded one guidance, the 2024 harassment guidance. And in doing so, it arguably ignored regulations arguably requiring notice and comment in order to do that. But that's kind of an aside. So let's go to the next slide. And let's talk about, the future of the EEOC records guidance. I think it's pretty clear that steps to undermine disparate impact rights are certainly not over. The 2012 guidance currently remains, but it's pretty clearly at risk. So I think in anticipation of that rescission, it's important to clarify what rescission of the guidance would mean and what it would not mean. Because again, one of the big things that comes out of these unprecedented actions is confusion. So first, importantly, the rights of workers with records and the responsibility of employers to respect those rights would not change just because guidance is rescinded. The rescission of a guidance does not change statute or legal precedent. The Trump administration, can't alter the laws or reverse court rulings without, action by Congress or by the federal courts. So that means that the guidance, even if rescinded, that document would still continue to accurately summarize the law. And, because of that persuasive value, it would likely still remain a helpful resource for employers, advocates, and even courts. So that's one side of it, saying like, everything isn't changing just because the guidance might be rescinded. But conversely, the rescission will nevertheless be significant. Like I said, it's going to result in confusion about the impact of rescinding guidance, and that may lead workers and employers to incorrectly believe that, their rights and obligations have changed. It's also going to lead to, decreased awareness and clarity about this area of law. And so more employers may violate the law and fewer workers may assert their rights. Um, and I think that, it's important to know also that as the EEOC further reduces focus on these claims, workers with records will have even fewer options for government assistance to investigate and enforce their rights. So, where they exist, state and local enforcement agencies or FEPAs are already overburdened and, unable to thoroughly investigate, let alone prosecute all the meritorious charges of discrimination. Um, so yeah, it's removing government resources to enforce these rights. I think in summary, the main takeaway is don't panic if the guidance is rescinded. Workers with records should continue to privately enforce their civil rights in court after receiving a right to sue letter from the EEOC or a FEPA or a state or local agency. And with that, I think I'm turning it back to Eric.
So we have some time for questions or short comments from the audience. So if you want to either write that in the Q&A function or raise your hand if that's an option. Let's see.
So
Well, okay.
sorry. I see that there's a similar questions that were asked regarding the logistics, and maybe LAC can answer that. But someone asked, I participated in the first session and I don't recall receiving my MCLE certification. Also, is there a recording of the second session? To which I responded, yes, thank you for your question. All of the recordings are available on laaconline.org /train/trainings, which LAC trainings also put in the chat. And we can follow up regarding MCLE credit. And then someone in the chat said, I need a password to access the trainings online. LAC, I don't know if y'all have answers to that.
To access the recording of it, no password is required. It's on the LAC website. I don't know if it's possible to get CLE credit that way, but it's definitely worth watching for the erudition. And and definitely feel encouraged to email myself or LAC about following up with CLE certifications.
Yeah, but if there aren't substantive questions, maybe before we get too far into the weeds on logistics, I think, Eric, you and I wanted to talk a little bit about like some of what's happening now and how what we've been talking about relates to ongoing things.
Advocacy efforts. There is one question before we get into
Okay.
some call to action. So someone asked, can you talk about sex discrimination and how it's related to the use of criminal records? That is something I have not heard about.
So in principle, the analysis or the rules for analysis would be the same. If if you have a prima facie showing of a disparate impact on sex, which includes, gender, sexual orientation, pregnancy status. If you have if the claimant can make a prima facie showing of that, then the burden shifts to the employer to show business necessity and job relatedness of whatever the practice or rule or policy that they're applying is. And then that could also be refuted by the claimant uh, with a less restrictive alternative or less discriminatory alternative. Sorry. Um, so yeah, so that's certainly possible. Beth, you want to add anything on that?
Sure. Yeah, I haven't encountered cases bringing this. I think there's one reason for it would be that statistically, I think women are incarcerated at a lower rate than men. But I will note that there is some interesting, and I haven't seen it brought into litigation, but there is some interesting research out there suggesting that when a woman does have a record, they are punished more severely by employers for having it. Meaning that, you know, that, and again, the research doesn't go all the way to fully proving this, but it's suggestive of the fact that maybe if a man and a woman both had the same record and applied for the same job, that a man might get it and a woman might not. I mean, we don't have that exact test to do. And the theory behind that is that women are being punished not only for, breaking a law in the past, but for violating kind of sexual sex norms and in their doing so. So I think that's interesting. It's something to keep an eye on, but I haven't seen it used in litigation yet.
Okay, I think you kind of answered the question, follow-up question, which is that theoretical or are there cases on that? To which Beth said she has not seen any cases on that yet. And then the next question is, do you feel that the disparate impact affecting employees with disabilities have a slightly different interpretation because that basis of discrimination is covered by Title I of the ADA? I just noticed it wasn't on the earlier poll along with the other basis of disparate impact discrimination.
Yeah, so that poll for which I'll take responsibility for drafting was just premised on the federal categories. So I was just using uh, the Title VII federal categories, but disability status is definitely one of the categories under 12940 of the California Government Code, and therefore would also be um, a basis on which a disparate impact claim under state anti-discrimination law and employment would could be deployed. And as you know, uh, the ADA on the federal level also deals with disability rights. I hope that answers your question a little bit. Uh,
Okay, next question is, are you seeing folks through Civil Rights Department mediation process for Fair Chance Act claims or taking those claim cases at all at your organizations?
So LSPC generally doesn't do direct representation because we're a support center, and but yeah, I don't know if anyone else wanted to add anything. We're almost running out of time, so I do want to shift gears for the very end of the program and just call folks' attention to a bill that's currently pending in the California legislature called AB 2095, which would revise the Fair Chance Act in California to uh, uh, amend Government Code 12952. Government 12 Code 12952 is a Fair Chance Act, which governs the use of criminal records in employment in the state of California. That's a bill that has made it through one committee and is on its um, way in the assembly, but still has another um, house to get through. Beth, do you want to add anything in the last few minutes?
Yeah, yes, I will. So please, yeah, keep your eye out for that bill. Although the Fair Chance Act, is and fair chance laws are, distinct from disparate impact, which we've been talking about today. They're definitely related. And I'll explain my thoughts on why. Um, so, even with disparate impact still intact, even without the tax and rollback of our ability to use that framework to protect civil rights, no one thinks the problem of discrimination against workers with records is fully addressed. Um, they're, complaint-based systems, hard to prove claims. Um, so I think the major takeaway there is that we need to be enforcing people's civil rights, but also combining that with other rights and other approaches to advancing the rights of workers with records. So, record clearing. There are some cities and states out there experimenting, you know, thinking about making having a record a protected characteristic in and of itself. So there are existing state laws and some city laws out there doing that, which could then, you know, you wouldn't have to go through this backdoor of, I wouldn't call it a backdoor actually. You wouldn't have to use this lens of disparate impact through the impact on race and national origin. Um, Circling back to what I was saying earlier about what's happening with the deprioritization of disparate impact claims of the EEOC, et cetera. Um, I just want to stress for everyone that, the reduced government enforcement, what that really means is that there's even more reliance on the private bar, and that the private bar is going to have an even bigger role in helping people assert their rights and defend their rights, which is already challenging. So hope folks are up to the task, and ready to step up. Um, so as I noted earlier, changing disparate impact jurisprudence is going to require court decisions. Like the Trump administration cannot change court law or court created law. There needs to be a court decision doing that. So my understanding is that, if you're involved in a disparate impact case, involving workers with records or otherwise, if the US DOJ, Department of Justice, or federal government takes an interest in your case, seeks to intervene, but wants to submit a filing, sound the alarm, because I think advocates across the country are wary of, that case coming that might be used as a vehicle to change our disparate impact jurisprudence. And I'll say that one group of people to alert it would be EEO leaders. There's a now website, eeoleaders.org. That's a bunch of you know former EEOC and federal folks who are very knowledgeable about this. And if that happens, if you raise it for them, I'm sure they'll know who you should go to contact. So I'll just leave that with you all as like some next steps as you're practicing in this area.
Thank you, Beth. And thanks to LAAC. And thanks everyone in the audience for joining us.
Thank y'all so much.